Hi, I've been asked to talk about how to the bar exam, particularly the MPT exam. I assume I've been asked about this because I've been having an exam club with some students over the course of years to work on their exam taking skills. And so far the students that went through exam club together have done really well, most of them. I wasn't 100% until this last bar exam, but unfortunately we didn't make it. And it made me go back and rethink what were we successful previously, what did we not do in the later exam. I think what in the last exam club, which was not successful, I think what we did wrong was we just took a lot of exams together, but we didn't really go through the theory of how to take an exam and go through the steps in terms of a system of how to take an exam. So what I realized was it wasn't helpful to take an exam and then evaluate, okay, how did you do on this exam? Because it doesn't show you how to approach every exam, because every exam may be a little bit different. So then I think the most helpful thing for taking or passing the MPT is to understand how to approach the exam and to have a systematic approach to the exam. So I'm going to be summarizing kind of my interpretation of the law school essay exam writing system, LEEWS. There is an online course called leews.com. And my experience is that students who take this online course do better in law school and better on their bar exams. The professor in that course mainly focuses on law school and law school essay exams. However, the same thing would apply to bar exams. And he does not have, in the online lecture, there is not a section on the MPT. There may be a section in his written materials, but I think that the approach would be basically the same. So first, my strong suggestion to you is you consider taking the online course. It could be a little bit expensive maybe, but in terms of improving your outcome on the bar, you're probably not too worried about your class grades anymore, but if you are still worried about your class grades, you can still improve your class grades by taking this system. Okay, so leews.com, Professor Wentworth Miller describes his essay exam writing system. And so the thing about his approach is it is a systematic approach for taking an exam. Because what happens is, and he talks about this, is on part one, the introduction, one of the mistakes students make is they get the exam and then it's very frustrating because on, let's say your essay exams in law school, you get 3 or 4 pages of text and you don't know what to do with it or how to break it apart into manageable pieces. So you just read it, you start reading it, maybe you read 4 or 5 pages of it, and then it's very frustrating because you're trying to do it all at once. You're trying to understand what's happening all at once. Oh, thank you. But most law school exams are not meant to be understood all at once. If the professor has a fact pattern, maybe one paragraph has he wants you to talk about some things. Another paragraph, he might want you to talk about other things. It might raise different issues in different paragraphs. So then as you read through the entire exam, you get frustrated. And same thing for an MPT, it's 20 pages. So what are you going to do? I mean, it's 20 pages, you look at it, you get frustrated, you don't know how to attack it. And I think that the biggest thing and the biggest frustration is, what do they want me to write about? On your law school exams, how do you identify what the professor wants you to write about? Because that's how you get a good grade. Dean Lee has 30 points on his contracts midterm. Okay, how could you possibly identify all 30 points? But you could apply the same system here we're talking about, or take Professor Miller's class and apply a system. You could identify all 30 points, and then you could write about those. You say, well, I only got 8 points on the contract midterm. Okay, you only talked about 8 things. But friend, my guess is you didn't just write 8 things. My guess is you wrote like 5 pages. Well, then you wrote 8 useful things and 5 pages of worthless things. We're just trying to find something that sounded legal, something that kind of struck your memory from class. You just start writing about it, hope you get some points. But that's not a great idea. You want to answer the question you've been asked. You want to give the reader the information they expect. You want to answer the question. So I think what's frustrating on the MPT is it's really a big exam. It's a big problem. And part of the problem, part of the frustration might be, what do they want me to talk about? What do they want me to write about?
제 청력에 문제가 있나 봐요.
Okay. I'm going to go through these steps with you, and if you follow these steps closely, and if you really follow them, you'll be able to identify what the examiner wants you to write about. Let's talk a little bit about grades. How do you get a good grade on your MPT? Well, first of all, you've got to produce the document they want. I didn't write that down, but I had some students, they asked for a memorandum of law, and the student produced an essay. It's not going to work. Okay. All they want to do is they just want to see, can you perform a lawyering task in a set amount of time? That's it. So this is very similar. You guys just go ahead and take time and go ahead. Everybody hit silent on their phone. So this is very similar to if you walk into your supervisor's office and they say, hey, we've got this case in, would you mind looking it up? And you go and look up in the practitioner's guide, you find the New York State Practice Guide, you pull it and you find the section on tort, battery, you find 3 cases on it, and then you answer the question based on that simple research. That's all this assignment is. But they just give it to you. So it's like you have a section of the state practice guide in your hand. And they're just asking you, okay, based on what you read, what's the answer to the question we asked? That should be your mentality. This is not impossible. The MPT is not impossible. It's very doable. It's very manageable. As long as you keep in mind what's the goal of it. Just to create, just to show that you can, in a set amount of time, produce a legal document. That's it. Can you do a lawyering task in a time constraint? It would be better if you had more time, but this is the real world. We can't give you forever. It just is what it is. I think the time constraint is unfortunate, but we need to be able to do this. So that's what they want. So then, what is your grade based on? Well, the main thing your grade is based on is, did you do the lawyering task? And what they mean by that is, did you handle the problem in a way a practicing lawyer would handle the problem? You don't have to take notes on this. Just try to follow. You can, but you don't have to. Just try to follow along with me, and it's all going to lock in together if you just think about it. So just think about it. The goal for the bar exam is to see, is there a legal mind on the other side of this exam? Is there a real lawyer on the other side of this exam? But that's what your entire law school has been. If you didn't know this, sorry, now you know. The way you get a good grade in law school is you show the professor that there is a real life attorney brain on the other side of the exam. So you can have a conversation with them there. For a law school exam like Civ Pro, Professor Ross wants to see, Did you handle the problem given as a practicing attorney would, who understood and who memorized the rules and understood what we talked about in class? For CivPro, your grade, his evaluation, A, B, or C, was based on, did this student handle this problem as a real-life practicing attorney would do, who has a knowledge of CivPro up to the rules we studied? That's it. That's what your grade's based on. Professors may not say that out loud, but that's what your grade's based on. So same thing for the MPT. In fact, even more so, because they want to see, is there a real-life, thinking, legal brain on the other side of this exam? So it takes a lot of pressure off. This is not an academic exercise. This is a very practical exercise. They only care about your practical thinking and your results. And so you're free to play the game. You want to be a lawyer? Okay, here's a problem. Show me what you can do. Show me your best arguments on this side and on this side. It's your chance to play the game and show them that you're a real lawyer. You can be a real lawyer. So you shouldn't be worried or anxious or nervous about this. You should be excited and anticipating a chance to show what you can do. So what might make you nervous? What might make you nervous is, well, first of all, on the MPT, you might be nervous about, oh, can I do it? Yeah, you can do it. If you're reasonably intelligent, you can do it. And you're all reasonably intelligent. So every one of you can pass the MPT. It's no problem. All right? So put that out of your head. The second thing that might frustrate you is you might say, well, I don't know what they're going to ask about. Yeah, nobody does. Who cares? They give it to you. You don't got to memorize anything. In fact, they say, don't bring your memorized law in here. Yeah, general knowledge, okay. Don't kick common sense out. But they're going to give you all the law you can use. It's a closed problem. So you're going to learn the law as you do the problem. That's all. But that's what we teach you in law school. You may not realize this, but we didn't really teach you the law. We taught you how to learn the law. So this is a good example of how to do that. So you shouldn't worry about that. It's 20 pages long. Can I read it all? You should worry about that. How many pages can you read? What's your reading speed? My reading speed, I haven't measured it in a little while. My reading speed used to be 50 pages a minute, which is not, 50 pages an hour, sorry. Technical reading, 50 pages an hour, which is slow. What is your reading speed? All you have to do is just set your timer as you read for your law school classes, and try to figure out what your reading speed is. And then you should start thinking about if the reading speed is pretty slow. I mean, let's say you read, say your timer, you read 20 pages. Okay, then stop your timer. Okay, how many minutes per page? How many pages per hour? You can do some simple math, right? A little algebra won't hurt you. So you should figure out what your reading speed is. And if it's a little bit slow, you're going to need to work on that. Because I think that's the main frustration for the MPT is, I just can't read it quick enough. I can't read everything. It's 20 pages. My English as second language isn't strong enough. Okay. Although, yes, you do need to increase your reading speed probably. What I'm going to talk to you about today is, don't worry about that. Not so much. Because we're going to go through a system of taking an exam, and frankly speaking, usually when I do bar club or when I do exam club with people, the first thing we do is I just sit them down and just give them an exam and say, take the exam, let's see what you do. Let's see how you take an exam. Let's just watch you. So they take an exam, and then afterwards we sit down and talk about it. Okay, 90% of the people, when they take an exam, they begin on page 1 and just start reading. and then they read page 2, and then they read page 3. That's not how successful people take exams. It's not efficient or effective just to start reading from the beginning. That's the wrong thing to do. Okay, so what should you do? How can you do it? So I'm going to finish up the introduction here. Your grading on the MPT goes like this. Did you talk about what they expected you to talk about? They're going to have a grading sheet. Whoever grades your exam, they're going to have a grading sheet, and it says, in general, they should talk about these 3 things. 1, 2, 3. If you don't talk about those 3 things, you're going to have a bad time. Now, if you talk about those 3 things, even if you don't get them perfectly right, you're going to have a good time. I guarantee, let's say there's 6 points for that exam, that MPT. If there's 6 points for that MPT, and you at least talk about the things they want to talk about, even if you're wrong, you're going to get 3 points, I think. And then the more things you actually get correct, you're going to improve your score. So the way people fail at MPT is they don't talk about the things that are expected, or they just don't produce a document that looks right. So I'm not going to go through how to write every document with you, but you should produce a document that looks correct. I mean, if it's a letter, it should be written in paragraphs with multiple sentences per paragraph, not just in bullet point, not just 1 sentence per paragraph, not funky, weird formatting. It should look like a letter should look. A memo should look like a memo should look. Man, I know maybe this sounds obvious to you, but in my experience of going through and teaching people MPTs, people who are struggling, who may not pass the MPT, one thing I've noticed is they don't actually make it look right. Their format is garbage. But if you don't speak English good, that's bad English. If you don't speak English well, at least your format should be beautiful. You can do that. So I don't know why it happens that way, but it always happens that way. So I'm not going to go through how to do your format. In fact, if you do Barbary, they're going to teach you specific ways to write a letter, to write a memo. Kind of a shorthand way of doing that. It's going to be quicker for the bar purposes. If they ask you for a memo, you should not produce a full memo like we taught you, fall semester, first week. Short memo, okay. But don't do a full memo format. Could you? Yeah, you could. It would be fine. Perfectly acceptable, but you don't have to. So Barbara's going to go through and talk to you about that, and maybe some other time we can talk about how to do each genre in kind of an efficient way. But at least make it look right. Make the format look good. If it's a letter, give it a letterhead, give it a date. Make sure it looks good. Make sure you're writing in full paragraphs. Okay. So your grade is going to be based on, did you discuss the things that they thought you were supposed to discuss? And did you do so in a way that a practicing attorney would do? And not just a practicing attorney who had these facts and only this law available to them. That's it. So let's talk about practicing attorneys. What's the difference between a practicing attorney and a law student? Well, first of all, you get paid. Second of all, practicing attorneys are always thinking in a practical way, all the way through to damages. Who can I sue? And who has the deep pockets? Who has the ability to pay? Practically speaking, can I get this person to pay? Can I get them in court? Are there going to be evidence issues? Are there going to be problems with this, technical problems with this? You need to have the mindset of a practicing attorney that's handling a real problem. Make it as real life as possible in your mind. Most law students only operate at the level of academics. What is a tort today? What is a law? Practicing attorneys are like, okay, I'm just going to do this. I mean, this is the law. This is what we do. We're going to, we file this case here. We do this way, this way, this way. So you've got to change your mentality from thinking about things as academic to thinking about it from a practical perspective. That's the beauty of the system that Professor Miller teaches is it shows you how to think in a very practical way. So what I'm going to talk to you about today is I'm going to show you what the A+ students, what they do instinctively. I'm going to teach you how they do it. Because if you ask an A+ student, how did you do that, they can't tell you. They're like, well, I just, And that's why it's hard to ask your professors, how do I take an exam? They'll just be like, well, you just spot the issues. Write IRAC. Look and, identify facts from the identify facts in the hypothetical that give rise to legal problems. Okay, the problem is, what they did instinctively, they may not know how to tell you how to do it. So I'm going to teach you a system that shows you, it breaks you down how to actually do it. And again, what we're trying to do here is, let's keep in mind the main thing. The main thing is the main thing. How do you identify what they want you to talk about? Let's say they have 5 things they want you to talk about. How are you going to find those 5 things? You ready? Okay. So the first thing when you get an MPT is you just want to make sure you orient yourself. Now, it's 20 pages, but you should look through how many pages is it? Are the instructions the same? By the way, you should make sure you read the instruction page from last year, or last summer, or last fall. Last, what, winter? Just make sure you read the instruction page already. That way, you don't have to waste time reading it again. You should already be familiar with the instruction page. And just look at it to make sure nothing changed. So just orient yourself very quickly. How many pages are it? How many pages is it? And are the instructions the same? This should take you no more than just 30 seconds. I mean, just glance at it, okay? The next thing I'm going to recommend is that you turn to the table of the contents and you just ask yourself, okay, right now we're trying to orient ourselves. What is this all about? What is this all about? What do they want? What is this all about? A lot of times, you can get a lot of information from the table of contents. You learn who the parties are sometimes. You learn, do they want a memo, or do they want a letter, or what do they want? You learn, is it a con law problem, a statutory law problem, or a common law problem? Therefore, where's the rule going to come from? Yeah, if it says Constitution Section 2, okay, we're in con law territory, right? If it says statute, case, okay, we're in a statutory law problem. So the rule's going to come from the statute, and then sub-rules from the cases, and analogies from the cases. If it's just case, oh, well, it's just going to be common law problem. That means the rules are going to come from the cases. So I have to get rules out of the cases and analogies out of the cases. So you can learn a lot just by looking at the table of contents. Help orient yourself. But what you really want to do, and you also want to figure out what type of writing do they want me to produce. What you don't want to do is just start reading from the beginning. First page, A, B, C, D, right? That's not helpful. So here's the first part of the system. I want you to orient yourself very quickly. I want you to figure out what document do they want me to produce. Do they want a memorandum of law? Do they want a client letter? Do they want an argumentative memo? Do they want a clause for a contract? Do they want a deposition plan or a discovery plan? What are the types of documents? You'll learn this in Marbury. There's umpteen types of writings they can ask you for. Usually it's going to be at least one memo or argumentative memo, and then maybe something else. So first of all, what piece of writing do they want from me? So what do I have to produce? If it's just edit a clause in a contract, hey, okay, not much writing. If it's produce an argumentative memorandum, okay, we gotta we're going to be writing a little bit. Just so you kind of get yourself aware of what you're writing. And in fact, if you find out what type of writing it is, you might go ahead and format it. You might take 5 minutes, or hopefully less. You might take a minute or two, just go ahead and format it. All right. But so far on step A, unless you go ahead and do your formatting for your type of writing, which you probably won't. So far on step A, you haven't written anything down yet. You have the exam, but you haven't put pencil on paper yet. And this is one thing I want to emphasize. You don't have time to take notes. You don't have time to highlight. You don't have time to write extensive notes on a piece of paper that is not going to be graded. You get paid for butt in chair, fingers on keyboard. That's what you do. Anything that takes you away from butt in chair, fingers on keyboard, it's not good for you. Yeah, you got to read, you got to understand, but how about you do this? How about you just read it and understand it? How about you just read it and remember it? Now, I get it. You may want to go through and mark a thing or circle a thing. Okay. But I've had students who have taken 3 colors of highlighters to these things. And then I look through them, and it drives me crazy. The 1Ls MPTs, I look through them and I say, the first round, I say, don't highlight, don't mark. I go through the stack of 60, I find out who, and this year I decided just to shame them. I actually called out their ID numbers in class and said, these ID numbers, I was going to use their names, but I decided not to use their names. But I decided to go ahead and name them and shame them, because it is so wasteful of your time. Highlighting does not help you. There are no studies that show that highlighting is effective. Maybe it is. That would be proving a negative, I guess, but there's no studies that show that it's helpful. I just don't recommend highlighting at all. Especially on this exam where we've already said time is at a minimum. Time is precious. So any time that you're circling something, marking something, that's time that you could have had your fingers on a keyboard typing later. So don't take notes. Read it and understand it. Okay. So from step A, 1, 2, 3, so far you haven't written anything. Nothing. Now, step 4, part 4, I want you to go ahead and write something down. But this is it. Who against who, and what do they want? So instead of starting on the first page and just reading down, I want you to skim and find out who versus who in court. Because we're thinking practically, right? So we're thinking, who would be the party opponents in court? But professor, what if it's a drafted clause for a workers? What if it's draft a clause for an employee manual? You can still follow this method because you should be anticipating who might be against who in court. What if it is evaluate a policy, evaluate a constitutional policy? You can still follow this. You can still follow this. Who would be on one side and who would be on the other side, and what arguments would they make? So practicing attorneys think about everything's got to go to court. If it's not, what are you doing here? Go see a psychologist. You came to a lawyer, and lawyers, ultimately, it has to be reducible to a court case. So that's how you should think. Who versus who? So who's my client? Who's the opponent? And then what do they want? What do they want to happen? Now, a lot of students make a big mistake here, and they say things like, they want equitable relief, they want injunction, they want whatever it is. No, I mean common sense language. Usually, for example, if you go to court, what's the usual remedy? Money. Usually people just want money. They want a piece of property. They want something to stop. So at this point, you need to think very, very common sense terms. Very, very common sense. What do they want to happen? What are they worried about? The only thing here I want to add is, on your MPTs, oftentimes there will end up being multiple problems, multiple objectives. I want to, for example, on an attorney's fees dispute, I want to get my money from my client, but I also want to protect myself from liability. You need to be, and this is key for the MPT, I think. When you think about these objectives, you need to really think about it from a practical perspective of what is everything that they hope or need to accomplish. And by that I mean things that could be accomplished in court, things that would have a remedy in court usually. So who versus who, and what do they want? Oftentimes, the quickest way is not to start reading at the beginning, but to jump down to what we call the call of the question, or the question itself. A lot of times if they give you a memorandum, like here's a memorandum from the senior partner, and then the actual question is at the end of that memo, right? Or like on an exam, it says, you read the whole thing, and then Dean Enlow's exam says, discuss every possible tort in existence, right? Okay, so this process works very well on that kind of exam. On Dean Lee's exam, it's more specific. Can this person have an interest in the blue cup? Right? Okay, for your MEE, for your bar exam essay questions, they're more like that. You'll get a fact pattern and then like 3 pretty specific questions. Okay, then just go to those questions and figure out, don't just start reading the facts. You'll get so frustrated. It's part number 1. Don't try to understand it all at once. Go read the question and then find the facts in the fact pattern that relates to that question. And it may only be 1 paragraph. 1 or 2 paragraphs. May contain all the facts relevant to that one question. But the first thing you do is you ask yourself, who versus who in court, and what do they want from a very common sense perspective. And this should only take you a few minutes. Because you're not doing legal thinking. In fact, you need to, you got to discipline yourself. I'm talking about a systematic approach that will work for every MPT to identify what they want you to talk about, but you got to follow the steps. Okay, no legal thinking, just who versus who, and practically speaking, what do they want? What do they hope to accomplish? You got it? In common sense English, no legal analysis. You're outlining overall, not including this step, your outlining overall should be less than 1/3 of your time. You got 90 minutes on an MPT, I don't think you should spend 30 minutes outlining. Now, I don't know what to tell you. You're like, well, it's 20 pages long, I have to read 1 page a minute. It's going to take me 20 minutes just to read the whole thing. No, because you're not going to start at the beginning and read to the end. That's not how you're going to attack the exam. So your outlining should be done, let's try to get it done within 20 minutes and then use the rest for your writing. I've seen students use 45 minutes for outlining, for preparing. That's not good. Normally it's because they're writing everything down in their notes and then they're going to start typing their paper. No, don't write things down that are not, you don't get paid for that. You only get graded on what you put down, what you actually type down. So don't waste time making your notes. Your outline should be very, very simple. You don't need to take a lot of notes, just read it and remember it. It's only 90 minutes, can't you just read and remember? Try to. Okay. So first, who versus who, and practically speaking, what do they want? And this should take you just a few minutes. And also, what document do they want me to produce? Just so you have that in your mind, right? What is this all about? Okay. Now, I think that's all you need to do for the first step. But sometimes students really want to find out what is the nature of this case? What is this case all about? Fine. If you want to take a couple minutes or a minute and just skim the facts to figure out what is this case all about, what's the nature of the case, great. But don't write anything down, please. Don't circle anything, don't mark anything. Don't read the facts from beginning to end. If you want to just skim through and say, oh, okay, it's a property case and they want this piece of property. That's enough. That's all you got to do. That's it. Who versus who in court, and practically speaking, what do they want? And if you need to say, what is this case all about? That kind of thinking, right? But all you wrote down was name the name. Money, not pay. That's all you've written so far. That's it. Next, we're going to go and we're going to read the library. That might... Have any of you guys taken and practiced MPT before, or taken MPT before? I know you have in your second semester. Did you just start reading at the top and read all of the facts? Probably. Did you read the library first? Okay, you need to read the library. Okay, so what's the point of reading the library? You got to learn the law. What you're trying to do, and please listen to me on this. Don't take notes on this. Just understand what I'm telling you. Who versus who in court, what do they want, right? And then when we look at the library, here's what we want to know. What tools are available to me to get that? That's it. What tools are available to me to accomplish that objective? What arguments are available to me to get that objective? What tool is available to get that objective? And then under that tool, where's the fight going to be? A tool might be something like battery. And then based on the facts of the case, the fight might be over intent. Lawyers are going to fight over intent. And this is what you need to remember. You're acting like practicing attorneys, right? So what would practicing attorneys argue in court on this case? Which tool would they use? Which legal tool would they use? Which legal tool would they pull from this library? And how would they argue about it? And play the game, both sides. They can argue this, but we can argue this. Show your legal thinking. Show your legal mind. Pass the MPT. It's that easy. That's it. What usually happens is students get they start reading the library and there's like 3 cases. They get confused. Which issue is relevant? Okay. You'll know which issue is relevant because you know who's going to be against who in court and you know what they want. So what you're looking for is tools to accomplish that. And if it's not, it's out. You don't need it. So we read the statute. Okay, what's the tool? Is there a tool in there? Usually there is a statute, usually the rule's in there, right? Okay, within that statute, where's the fight going to be? Here's a tool to get what my client wants, and out of these elements, probably the fight's going to be about this third element. Okay, write it down. Write down the name of the tool, and write down where the fight's going to be. The statute is a battery statute, and the tool is going to be intent. There's no statutes. And that's it for your outline. You're also looking for counter tools. Is there anything that your opponent might use? Now, if your opponent is just going to argue the opposite, don't write it down. You'll naturally go back and forth. You'll discuss it back and forth. If it's just, I think the element is met and they think that element is not met, don't mark it on your outline because you're going to discuss it, right? There's no point in outlining it. Only if there is a separate tool available to them, such as if there was a battery and they had a tool of self-defense, then you might want to write that down. And then out of self-defense, where's the fight going to be? Usually about reasonable force. Okay, write down reasonable force. Okay, and then your outline is done. So as you read through the library, what you're looking for is, what are the legal tools available to me to accomplish what my client wants? What are legal tools available to them to make their argument? And where's the fight going to be within that tool? Now, how do you find those tools? Well, if it's a statute, it's probably going to be in the statute. That's going to be the general rule. Then we're going to read the cases, and we're going to be looking for specific rules that help us better understand how to interpret that. As we read the cases, we're looking for, what were they fighting about in the cases? Probably, we're going to make the same arguments, right? So you're looking for any additional rules, and you're looking for analogies. How were the rules applied in a factually similar case? So I can argue it should be the same in my case or not, right? Friends, I had one student taking MPTs. He was taking forever. I said, what are you doing? I found out that the student was case briefing each case. I'm not kidding. I mean, the student must have had like 5 pages of notes. Well, no wonder you can't finish an MPT. Don't take any notes. Just read it and understand it. If you read it and ask yourself, as you're reading the case, ask yourself, how can I use this case to get what I want? How could they use this case to get what they want? You're going to understand the case. You don't need to outline what the facts were because you're going to be reading that case for the facts, for the holding. Okay, so as you read the rule, as you read the cases, I recommend that you don't case brief it, A. B, don't write or highlight them. C, think to yourself, why did they put this case here? Why is this case here? How does it help me? How does it help the opponent? Why are they giving this to me? Now again, in the context of what does my party want? What does the other party want? How can I help them get that? That's the context, okay? So that helps us when we go read the rule and read the cases. We have in mind something. We have an objective in mind, objectives in mind. Then we're going to read the cases for that objective. And friends, that's how real lawyers read cases. Not like in your law school where they just give you a case and it's not even relevant to a problem you're facing. You're just reading that case to learn the law or something. I mean, not many lawyers are reading cases to learn the law. They're reading cases in the context of a fight. So that's what you got to do. As you read the statute, is there a tool available to me to get what my client wants? In this case, is there a sub-rule I can use that shows how that should be interpreted for my client or the opponent might use it? How are the facts in this case similar to my case? Such that a result should happen or not. One thing I'll tell you is, as you read through cases, you're going to be seeing possible fights. Like for the attorney's fee dispute. I don't want to pay. So you read through the cases and you see, okay, this happened in this case and they didn't have to pay. I'll argue that. Here's a tool available to me. Here's a concern, I think the difficulty for MPTs is, as you read through the fact pattern, you've got to think very practically, we'll go through some, and we'll go through some examples and look at them. Who are the parties? What do they want? In plain language. And then what tools are available to me to accomplish that? So then, your outline should look similar to on the back of this page. Your outline should look like this. Smith versus Johns. Money, not pay. Battery, intent. Self-defense, reasonable force. That's it. And then, you might put the name of the case that's going to help you out on each of these. You might just know the name of the case real quick, so you don't have to come back and look it up again and find out which case was that. But that's what it should look like. Now, after you read the library, go back and read the facts more thoroughly and carefully to identify which facts are going to be useful in our case. Which facts are similar to cases you just read? Being an attorney is all about precise fact detail. Application of precise facts to rules. But that's why I don't really recommend reading all the facts first. I'd rather know what the law is and then go back and read the facts. Now, as I take the practice, when I'm with the students, I do the exam also. I've gotten fooled before. I thought the case was about something. I didn't read the facts carefully enough up front. I thought the nature of the case was about something. And then I started reading the library, and I was like, oh, I was wrong. It's got to be about something else. I was wrong about what this case was about. And go back and look, okay. I see what the case is really about. Okay, look at the library, learn the rules, learn the cases, then go back and read all the detailed facts. Okay, why is that important? Because if you identify what the rule is and where the element is where the fight's going to be, then you can realize which facts are relevant to whether that element is met or not. Otherwise, if you just start reading the facts, again, it's like we say at the top here, don't try to understand it all at once. You're going to get frustrated because you're reading all the facts, but you don't know how they're legally relevant. Now, are there other ways to take the exam? Yeah, you could just read straight through it. That's okay too, whatever. But still, I would recommend doing this outlining process. Okay, who versus who, and what do they want, common sense wise. Then, what tool is available to me to accomplish that? And where's the fight going to be within that tool? And usually there's going to be more than one tool available to you. There might be 3 or 4 points on the MPT they want you to talk about. How do I know what they want me to talk about? Well, what would real life practicing attorneys fight about in court? How do we know that? Well, they're trying to accomplish their client's goals and objectives. So real life attorneys are going to use the legal tools available to them to accomplish those goals. And then within those tools, then you think about, okay, well, who's going to fight? Who's going to say what? Who's going to say what? What facts can they use? What facts can I use? And it's all about precise fact detail. In fact, I'll go so far as to say that if you identify the legal tool available, the issue within that legal tool, the facts they might use and the facts we might use, your conclusion ultimately doesn't matter. The bar examiners are not looking for a right answer. They're looking for your logical process. They want to see, do you have the mind of an attorney? Can you recognize what is a relevant fact and what is not a relevant fact? Sure I can. How? Because I thought about what my client wants. I thought about what tool is available to me to get that. I thought about where's the issue under that tool, and therefore the only relevant facts are those that are relevant to whether that issue is met or not. Usually it's an element of a statute. Do you see? So I've talked about what they want me to talk about. I've identified what they want me to talk about, and I've talked about it. In excruciating fact detail, applying the rule to the facts of our case, and playing the game, getting both sides. Well, what if they're asking for an objective memo? Well, sure, you should say, we can argue this, but they can argue this. What if we're making an argumentative memo? Should I play both sides? Yes. Give your argument, rebut what you think is their best argument, and then make a conclusion. Show that you understand. Show that you see the shape of the argument. Some people are a little strange. I don't know if you know this. My wife sees colors when music is played. I found out one time that Dean Enlow sees arguments as if they were like Tetris blocks. So it's very difficult to argue with him because he's already seen like 5 blocks ahead. If this block goes here, this block has to go here, this block has to go here, this block has to go here. This block has to... The most frustrating thing about Dean Enlow's, talking with him sometimes, is when, I obviously haven't fulfilled my role as a conversational partner, and he starts arguing against himself. I'm like, man, yeah, I'm dumb. Sorry. You're like, well, what people kind of say sometimes is this. Okay. Thanks for making my argument for me and then destroying my argument. I think today in faculty lunch, he's like, well, what if your argument was this? And he made the argument as best as it possibly could be. He's like, but then what if somebody said this? And the other professor's really quick. He's like, oh, well, yeah, that's good. Well, then I would say this, and I would say this. And then we're all sitting back there like, I know who Thomas Aquinas is. I can spell his name. Okay. But what you're trying to show the reader is that you recognize the arguments that will be made in court. You recognize the shape of the arguments. Who's going to argue what. So this is the main thing. First, we're just going to find out who versus who and what do they want in practical common sense terms. We're going to go to the library and identify tools available to us and try to identify where the fights are going to be. There's 4 possible fights I can raise about this. Okay, great. Go back to the facts and figure out from the facts how to fit the facts into those fights, which facts are relevant on both sides, and then start writing. And you need to produce the correct document. But that's it. And this works for everything. It works for drafting an employment agreement. It works for drafting a contract clause. Just think about who would fight, if it goes to court, who's going to argue what? Who would fight what? How do I avoid court? How do I avoid a fight? Where would the fights be? Where would we have to argue and they would have to argue? So even if you're doing a drafting assignment for your MPT, the same approach will work, okay? I promise you. And then you want to start writing, and just remember, they just want to see, do you understand what reasonable lawyers would argue about in court? And they honestly don't care about your conclusion, as long as it's reasonable. And don't forget to be super practical. Analyzing all the way down to the outcome. Analyzing all the way down to damages. For example, on your torts exam, did you go all the way through to damages, to punitive damages? Did you say something like, you guys had 3 L's, no, it wouldn't be your exam. Hey, the guy who threw the pie, he's an 18-year-old kid, he doesn't have any money, so practically speaking, why would we sue him? Because we can only recover nominal damages at best. If you didn't say that on your torts exam, why not? Why didn't you go all the way through, practically speaking, all the way through to what the client wants to accomplish, and is it possible, even? So what is wanted is practical, common sense attorney thinking demonstrated in 90 minutes to produce a typical written genre. Or put it another way, do a lawyering task in a set amount of time. Can you act as a practicing attorney to do a lawyering task in a set amount of time? Okay. So, do you guys want to take a break? Or do you want, I have an MPT we can do a practice run on.
Maybe take a break.
Okay, so let's take a break and come back at 4:15, and then we'll take a practice run at an MPT. Okay.
A few minutes later.
4:15. That's fine, but I think it's actually more difficult to read and type because how do you turn the pages? I think it's a little bit easier to read and do like a handwritten outline. So for that reason, I recommend doing a handwritten outline. Are you looking at me like I'm crazy? Like, is that okay?
Can I bring change paper?
Sure. Or whose paper is this? Paul, as a model follower of Christ, is not going to be called a teacher father. It's got to be Enla. Here you go. Pippin, here's a piece. Take this piece of paper. Seeing that is like seeing Enla was here. Do you need a piece of paper, anybody? Okay. I don't know who this is, but they left it here, so they're out of luck. Anybody else?
I need one.
Okay. All right. Next, we'll get on the praise team. Start using the praise teams.
No.
Okay. First step. As you open the exam, I just want you to identify who would be versus who in court and what does each side want. I'll give you 2 minutes. Go. Okay, time's up. Who versus who? Who? So which meanie? Okay. Brandon meanie versus?
Trustees of the University of Columbia.
Okay, you don't gotta write everything. Just write. You say, you can write meanie, but the problem is maybe you get a little confused. I got confused at first. Did anybody turn to the last paragraph? And the last paragraph said, Edward's gift, right? On the memorandum, the last paragraph says, prepare an objective memorandum assessing whether Edward did indeed transfer the garden to the trustees by way of contract or gift. Do not include a statement of facts. Okay, so if you just read that last paragraph, you might think it was Edward versus the trustees, right? But then I thought, oh, wait a minute. It could be somebody saying this guy didn't give it. So there's probably a different party involved. Then I flipped back and started reading the other page. I just skimmed the facts. I didn't sit there and read from fact 1. So you should have read we have been retained by the trustees of the University of Columbia to defend them, right? We're going to skim and find out who versus who and what do they want. So what does Brandon want? What's his objective?
To prevent the trustees from selling.
Okay, how can we say that very simply?
Don't sell garden.
Okay, don't sell. Okay, what do trustees want? All right, did anybody write down something like injunction? Or clear title? Or breach of contract? Anybody write those things down? That would be wrong at this point. We're not writing anything down legal right now. Just who versus who and what do they want. Do you see how this helps to focus you on the whole MPT, what do they want me to talk about? Right? Okay, so this is going to help you identify what they want you to talk about. It's going to be Brandon versus the trustees. He wants them to not sell the garden, and they want to sell the garden, right? That's it so far. And did you do that in less than 2 minutes? How'd you do? Not quite? If you didn't do it in 2 minutes, you weren't reading correctly. Maybe you didn't go to the last paragraph and then skip back. Maybe you started reading from the beginning. Maybe you spent time looking at table of contents, reading instructions. Anybody read instructions? Hope not. You should have gone right to the facts and just find out who versus who and what do they want. What is this case all about? Okay, so the problem is you could get, in writing this problem, they put in big dangers for dumb law students. A dumb law student is going to say, oh, this is a breach of contract case. They're going to start thinking about contracts. Because the first sentence is what? Right? So they're going to start thinking about breach of contracts. They're going to go off on a tangent. They're done. They didn't pass. Okay, but you only got to beat 50% of the people, right? You only got to be better than 50% to pass the bar. So that's all. Don't fall in the trap. And then later we find out in the last paragraph it says, we're being sued for breach of contract, but I think I can get it dismissed for lack of standing. Do you see that on the bottom of the first page of the memo? It says lack of standing. Okay, so a smarter student has already said, oh, it's going to be a standing issue based on the nature of the gift or contract. But we're not there yet, okay? But if you're just reading through it and trying to figure out what's the nature of the case, what's this case all about, who's suing who, and what do they want, for now it's enough to say, Brendan wants them not to sell, and they want to sell. And we know it has something to do with if it's a gift or not. Now, normally what people would do is they start reading the agreement, right? How do you know what facts are relevant in the agreement? You don't. So what are we going to do? Well, now we're going to turn to the library. So we did step A. Done. 2 minutes. Easy. Now we're going to go and read the library. Okay? And in reading the library, what are we looking for? Help me out. What are we looking for? Tools to, not law, tools to get the objective. Exactly. Right on point. What tools are available to me in this library to get what I want? Now I put Brendan over here and I put the trustees over here. Why? Yeah, I mean, plaintiff defendant, but it's usually better to think about it as moving party versus non-moving party. Brendan is the one who'd have to bring the suit to prevent them selling, right? So I put him first. But I'm kind of wondering about that because if it's a standing issue, they're challenging a standing issue, would they have to bring the motion to dismiss the case for lack of standing? Yeah. So then maybe trustee should be here and BM should be here. But you know what? It doesn't matter. Because the bottom line is talk about what they want you to talk about, right? Does it matter who versus who in your outline? No. Don't worry about it. All you got to do is identify who versus who in court and what do they want to accomplish. What is this case all about? That's it. Now we go to the library and we try to identify what tools are available to us to get that result. And we have a general idea. It's some kind of issue about gift or contract of a piece of a garden of a piece of property. Okay, bless you. All right, got it. Okay, so go to the library. What's the first thing you notice about the library? Exactly. He said it's common law. How do you know it's common law? There's no statute. It's 3 cases, right? Okay, I see 3 cases. Now, the reason that matters is we need the rule and sub-rules. In common law, where does the rule come from? Cases. So we know we're going to pull the rule from a case or cases. And we might also get a sub-rule from one of the cases to help us apply an element or something. So we're going to be looking through these cases for rules and sub-rules. Also, we're going to be looking through these cases for analogies. What are we looking for? Are we looking for breach of contract? Are we looking for gift? Yeah, we're looking for some situation where a piece of property or something, does that have to be property? Is that relevant? Something was given in trust, or was it a contract or a gift? That's probably what we're looking for. I don't know. I've never seen this problem before in my life. So this is new to me also. So let's look at the first case. I don't have any advice for you on reading cases. You just got to read the case. Maybe Barbary has better advice for you. My advice for you is read the case and don't make any notes. Don't highlight anything. If you can't help yourself, circle something, okay, all right. But that's it. Don't make any notes on it, okay? Let's all read the first case, Barron's case, and then let's talk about it, okay? Ready? We'll take 5 minutes. Go. As you read it, if you find a tool available to you, mark it down in your outline. Okay. I like using California MPTs because they're so darn simple. Compared to real MPTs, it's like baby MPT. Okay, did you find a rule? What rule? Okay, so there's our trustees, we're the ones who want to defeat him, right? So what's the rule available to us? Okay, so our tool available to us is absolute gift. Right? And then within that fight, where's the fight going to be? Whether the gift was absolute, where's the fight going to be? Vipin, I don't understand that. There's going to be a motion to dismiss, sure, but who cares? Under absolute gift, under this tool, what would lawyers argue about? What would they argue about? What would we argue about? Okay. And you also mentioned the presumption, right? Yeah, I mean, there's like 1, 2, 3, right? If there's a presumption, it has to clearly appear. And there are some other little language in there, like the donor is the master. I might have written that, How much do you write down? You should keep your outline pretty simple. I mean, if you said something like donor master. Just remind yourself to write it down later. And then, do you want to write down the 3 elements? I might go ahead and type those in. If you already got your document ready, you just go ahead and type those in because you know you're going to have to anyway, right? Cut and paste them. I would not write them on my outline because it's a waste of time. Unless you just abbreviate them quickly and then you can type them later. But again, everything you write on your outline is wasted time. So you got to think about it. Now, it's better to write it on your outline than to flip through the pages again and try to find it. You don't want to be sitting there during your exam flipping through, where was that? Where was that? It's wasting time, right? So the best advice might be to go ahead and start writing your, by the way, what document are we producing? Objective memo. So we know what we need. We need an intro, we need rules. We're going to IRAC it, right? Intro, then rules. We can go ahead and put all of our rules. Go ahead and start drafting your rules. Under Columbia Civil Procedure, Columbia Civil Procedure 12b-6 allows dismissal for lack of standing. Did you find that? Here the general rule is the donor is the master of a gift and can make a gift that's absolute or not absolute, depending on whether they restricted use, power modify, reserve the right to sue or force, right? Has to be clear, and it's presumed to be absolute unless it's clear. You could go ahead and that's all the rules for this case. You could go ahead and write those down in your answer, and then you won't have wasted any time. So I do think there may be a benefit in beginning to draft your document already and just go ahead and put the rules in as you find them. I don't know. Okay. Are we going to use this case as an analogous case? Is it factually similar? We don't know yet. We do know, the only facts we have is that their instrument says hereby delivers and hereby accepts, and that's all. Hopefully ours says more than that, but if ours only says hereby accepts and hereby delivers, then we're going to have the same situation, therefore same result. My guess is ours is going to be somewhere in the middle. But, so yeah, we'll probably use this as an analogy. Should you write that down? No, just remember it. You read it, just remember it. In that case, hereby accepts, hereby delivers, not enough. I mean, sure, if you gotta write it down, number one, there's no right to, what's the first rule? You didn't reserve no right to use or dispose, no right to modify, no right to enforce, and we write down, what's the name of this case? Barrener case, only hereby gives, hereby receives. That's probably too much for an outline. You should just read it and remember it. But if you want a quick note, okay. And nobody, can you read this? No. Nobody has to be able to read your outline but you. And remember, you don't get paid for your outline. So don't waste time on it. Keep your outline really, really simple. So for me, I don't know. Just that. I don't know. Whatever, but if it keeps you from having to turn back to the page later, okay, just make a little note. We gotta save time, right? Okay, next case, let's do it. Did you find another tool available to you to accomplish your client's goals? What tool? Okay, so the tool would be, you found the tool called gift, right? Yes. Good. And then also you told me you found the four elements. That's good. Which element would be in dispute?
Consideration.
Done. Okay. You're great. You're golden. And then within consideration, where's the fight going to be? Not intent, what's the right word? Motive, thanks. Close, but motive, right? Done. Great job. That's it. And of course, you need to remember the facts. Hey, after the first case, weren't you tempted to go back and look at the contract? Right? So tempted. Okay, so then, I mean, you could, but... All right, so we've got two things right now. Absolute, versus non-absolute, right? And then gift, consideration versus motive. And you can already see the shape of the argument, can't you? What's going to happen? What's the first thing we got to decide? What's the first thing we got to talk about? Non-absolute. And then what about for this one? If it's absolute gift, what did this court say? What did the Collins decision say?
No need consideration.
Absolute gift, you're done, right? But for non-absolute gift, then what? You need to look at consideration, right? It even gave a great example of what if a university, you donate money, and the university says it's going to name something for you. Is that enough consideration? What do they say? No, right? He gave another example of the case itself. So he gave a hypo, dicta, and then it gave the case itself. What about the case itself? In this case, was there consideration? What did the court say? Yes consideration or no consideration?
Not a consideration because it's nominal and immaterial.
Well, go back to we got to be very precise. No consideration because the motive was what? Was the motive commercial or non-commercial? Non-commercial. But Dean Lee taught me if you say I agree to keep the property for ecological reasons, it'll be consideration. I've changed my legal status, therefore I've accepted the burden. Therefore, it's consideration. Of course, he used to be piercing that and saying, "Well, we're going to look, is it really consideration or not?" Okay, that's their rule. Okay, so far so good. Last case, let's do it. Okay, this case is both very easy and very hard. I think California puts cases in just to mess people up. So as a practicing attorney, when I read this, I skimmed the first 5 paragraphs. It didn't matter at all. When I read this case, I'll show you how I read it. It starts out really hard, right? Almost 100 years ago, Ralph Polk created the Polk Trust by giving trustees like that, right? I read it as, who cares, who cares, who cares, who cares, who cares. And then I didn't start paying attention until the paragraph, the sole issue. You see that paragraph? Because my eyes saw have standing to sue. When I saw have standing to sue, I went, oh, wake up, that's one of our issues, right? Standing, possibly. Okay, so then I started reading from there. I didn't read the whole thing, I just kind of skimmed those down to there, and then I started reading. The AG has standing to sue. These jurisdictions accord standing to any person with special interest. Okay, so then as soon as I saw that next paragraph, the top of the page over there, I wrote down on my document, I wrote down on my paper, person of special interest. Because I guessed, okay, that's going to be the tool available. They're going to argue that maybe he's not a person of special interest. So then I started wondering, well, who is a person of special interest? Curiosity got the better of me, so I started reading it. Like, I got to find out how do we define that, right? So what's the rule for who's a person of special interest? It's on the last page, top of the last page. Persons who are trustees, beneficiaries, or otherwise have an ownership interest in the property. Okay, I'm going to ask you the same question I keep asking you. Where's the fight going to be? If you were a practicing attorney, where would you fight over this? I mean, did the facts say that he was a trustee? Brendan Meany's a trustee? Brendan Meany's a trustee? Do the facts in our case say that Brendan Meany's a trustee? Vivian, you don't have to guess because he's suing the trustees, bro. Is he a trustee? He could be a minority, but then, hopefully you got enough out of the facts so you didn't see anything like that. So, okay. But even if you didn't, you say, well, okay, I don't know. He has to be a trustee or a beneficiary or have a what, ownership interest?
Yes.
That's the one I marked. I said, I bet they're gonna argue, I mean, it's not his garden, he didn't give it, but they're gonna argue it's not. When I skimmed the facts, I also saw that he was her son from a previous marriage, as I skimmed the facts in that 2 minutes. So then I thought, oh, I think they're probably gonna argue there's no ownership interest, right? Okay. Friends, you now know what you gotta talk about. You know, what do they want you to talk about? What do they want you to talk about? Tell me. 3 things, right? What 3 things? Absolute gift. What's the next thing? Consideration. And what's the next thing? Person of special interest. And specifically, so you gotta figure out absolute gift. Did it clearly appear? We know there's a presumption against it, right? Did it clearly appear? For gift, where's the fight going to be? Motive, right? And for person of special interest, you may not know yet. Is he a trustee? Is he a beneficiary? You know, because it's the son, maybe he's a beneficiary of a will or something, I don't know. Or does he have an ownership interest? I don't know. So now what do? Now we go back to the facts. Since we know what's relevant, now we're going to be looking for relevant facts only on these issues. That's how we know what relevant facts are. Am I going to talk about breach of contract? Am I going to just like dump down on the thing? I'm going to dump down. A contract is an offer and an acceptance, valid consideration. Breach of contract occurs when a contract is, and you can get remunerative damages, you can get compensatory damages. Am I just going to vomit up everything I studied on the bar? No, I'm going to talk about what they want me to talk about. How do you identify what they want you to talk about? That's the scary thing on this bar. On the essays, you can do the same thing on the essays. Who versus who, what do they want, just practically speaking. Okay? And then what tools available to me? Okay, I know it's an evidence exam, so probably exclude evidence, keep evidence, right? Which tools available? Hearsay rules available? Under hearsay, what would they fight? What would I fight? Like I would say presence since deception. And then they might say this. Okay, that's what they want you to talk about. Then just talk about that. That's it. You see how it works? And then play the game back and forth. We're running out of time. So as you go back and read through these facts, you're going to find out things like, he was her son from a previous marriage. She really loved the garden. It's got her name on it now. Now, dumb students are going to just fall into like, hey, it was changed to her name, and is that legally relevant at all? No. So don't get, because you know what facts are relevant based, because you know what the rules are and where the fight's going to be, then you know which facts are relevant and which facts you can ignore, right? Then you can arrange it. So to write this memorandum, all you would need to do is give a little intro paragraph. You would say, memorandum of law, right? This memorandum concerns a piece of property, blah, blah, blah. The issue here is whether the plaintiff, Brendan Means, has standing to sue to keep the trustees from selling it. Done. You see, it's so easy. Then you just start out you put a bold thing that says, absolute gift. Bold, right? Absolute gift. The first thing we should determine is whether an absolute gift has been made. Actually, honestly, I would do 1, 2, 3. Because whether he's a person of special interest is a technical issue that should be addressed first. That's how lawyers would do it. Because if you don't have a special interest, then how can you sue in the first place? Come on. Okay, so is he a person of special interest? Let's write that one together, because that's an easy one to write. You don't need to look at the agreement. All you gotta do is look at the facts. You don't need to write anything in fact. I just want you to read the facts from the memo and then I want you to be able to argue with me both sides whether he's a person of special interest. Are you ready? Go. Just get the memorandum out and just read, skim through the facts. Look for Brendan, and don't read the whole thing. Look for Brendan Meany. Find out who he is. Just skim till you find Brendan Meany. Did you find the word Brendan in this paragraph? Okay. It should be enough time. So when we write it, remember, this is very crucial. It's all about precise fact detail in your argument. And argue both sides. Precise fact detail. So first of all, you begin your memorandum. In your introduction, you just give the nature of the case and an issue statement, and that's it. Then you put a heading that says, person of special interest. You don't even need to write, one issue is whether Brendan is a person of special interest, right? You can skip that because you wrote, person of special interest. So the reader knows that's an issue, right? You could give a little, if you want to give a little roadmap, that wouldn't hurt. There are 3 things to discuss, 1, 2, and 3. That wouldn't hurt. Okay, but keep it simple. Don't write, the issue is whether Brendan is a person of special interest. It's just wasting time. This is bar exam. Don't waste keystrokes. Every keystroke counts. So all you gotta write is the rule. Start with the rule. I know, I told you don't do this usually. This is bar exam. Not creative writing. Just show them that you understand what's happening. Show them that you have legal thinking. That's all you gotta do. Okay, so what's the rule for person of special interest? Right, so you might start off and say, for non-private charities, in general, the Attorney General has the standing to sue. However, show that you can pull a rule out. However, any person of special interest also may have standing to sue. What's the sub-rule for person of special interest? That includes a person who's a trustee, a beneficiary, or has an ownership interest. Right? Here, in our case, ready? Here, in our case, so what do you think? Does Brendan have what are the facts that would show you he does or does not have an ownership interest? Here, the plaintiff, Brendan Meany, is the child. He's whose child?
Sarah.
Who's Sarah? I don't know her. Who's Edward? The son of the donor's wife by a previous marriage, or how are we going to say? The only son, he's the only child of the donor's wife, but was born to her by a prior marriage. Those are the facts. Any more facts as to his interest? Does it say, is he a trustee? Does it say, is he a beneficiary?
No.
Does it say, does he have a property, does he have an ownership interest? Okay, then we've got to argue. What's our best argument as the trustees that he does not have a property, he's not a person of interest? Well, help me out here. Apply rule to precise facts.
He is not the son of donor.
Okay, he's not the son of the donor. What does that mean? What is a beneficiary? Where does beneficiary usually come up? Okay, so he's not the son of the donor, but what do you mean by that? Why are you saying that? Why does that fact matter? Okay, so maybe he's not a beneficiary under the estate. The gift was from the donor. Does the gift mention the wife? It doesn't. What is his ownership interest? Does he have an ownership interest? So we've got it. You can't just say he's not the trustee, beneficiary, or ownership interest. You have to demonstrate your thinking based on precise facts and who can argue what back and forth. Because he's the son of the wife by a previous marriage, it's not clear that he is a beneficiary to this property or that he has any ownership interest in this property. In fact, why do you think he's getting mad? Why do you think he's suing? I doubt it. The property's given away. It's in trust. Why is he getting mad? Think practically. What does he want? Why does Brendan Meany, why does he want them not to sell? Think practically. Why does he want them not to sell? Why? He has nothing to do with the garden. It's been donated. It's in trust. He has nothing to do with it. Think smart. Think practically. What from the facts give his motivation for suing?
He wants to take back the house.
Is it because it was his mom's favorite garden?
Okay, it's his mom's favorite garden. And what else about that?
Maybe that's why he
No,
wants.
fact.
It's known as Sarah's.
Okay. So why do you think he's pissed that they're trying to sell the garden?
The title will be gone. Nobody will remember
Right, the title, not the title of property,
the property.
but the name of the property. Okay.
The name of the property.
Yeah, because it'll be turned into a parking lot. And what is it right now?
Garden
Garden.
commemorating his.
His mom's named garden.
Yeah.
Okay, but how does that help us? What's our argument? He has to have what? He has to be a trustee or beneficiary or have some kind of ownership interest. Are there any facts that demonstrate that he has, are there any facts that indicate he's a beneficiary or has an ownership interest? No. Are there facts that imply that he might? Yes, absolutely. Absolutely yes. A practicing attorney would say, I wonder if that property somehow went to Sarah, and then, think about it, if the trust is broken, the property reverts to them, right? Then, in that case, who would get the property now if the other people are dead? I'm not sure the donor's dead, but it's not clear to me if the donor's dead, actually. She's dead. So, his ownership interest or beneficiary would have to come through her somehow. But he was the son of a prior marriage, so it's possible that she made a will after she got married, and then there's some kind of possibility there, right? But it seems pretty weak. The facts don't say, I didn't see the facts say that Edward died. Do you? I don't. So what does it seem like? What is his interest in that property? Is it beneficiary? Is it ownership interest? What's our argument? If you got up in court, what would you argue to the jury?
He has no interest.
Yes, no, what kind of interest does he have? What kind of interest does he have? That's not what you'd argue to the jury. What kind of interest does he have? Okay. Why am I thinking this way and you're not thinking this way? This is how you pass the bar, is by thinking practically like an attorney would think. By thinking, how would you argue this? So you should have analyzed the facts like I did. You should have seen, hey, there's something wrong here. The donor doesn't seem to be dead. The donor's the one who gave the property. His mom died, and she had been married prior to him. The marriage came later. So maybe he has some kind of interest in her estate. Is that property included in her estate? I don't see any facts like that. And then I thought, well, so what's his dog in the fight? This English phrase, like, what's his dog in the fight? Oh, it's the garden named after his mom. So what kind of interest does he have in the property? He has emotional interest. That's what we would argue to the jury, obviously, right? You would say, hey, I understand that you are interested in this property because it's named after your mom. It's your mom's garden. Cusco's garden. The garden after Cusco. Cusco's garden. Nobody Emperor's New Groove fans? Disney? No? Anyway, okay, so it's his mom's garden. He has an emotional interest. But buddy, does the law care about your emotions?
No.
Yeah, that's what you argue, right? You just say, hey, we're sorry, but we understand you have this emotional connection to this thing, but legally, to sue, you actually need some kind of interest here. Now, talk to your stepdad and see if he wants to do something, I don't know. But you may not have standing. Okay, so if you decide he likely does not have standing as a person of interest, first of all, you don't know, you've got to imply some facts. If you have to imply facts, just let the reader know. You can say, the facts don't indicate that he may have had some interest in his mother's estate. It's not clear from the facts that would include any interest in his property. It just doesn't look like he has any kind of beneficiary or ownership interest. It looks like the donor is still alive. The facts don't say that the donor is dead. Precise fact detail, you see? Precise fact detail. Now, let's say that you decide he has no property interest. Stop writing the memo? No. I'll teach you a nice phrase you should memorize. I gotta open the pen. Assuming arguendo. Assuming arguendo. It sounds so legal. See, it sounds so nice. It's a way of communicating to a reader that you're going to make an assumption, or you're going to go off outside the facts a little bit. But in this situation, you would say, assuming arguendo that he is a beneficiary or has a property ownership interest, then we still need to consider the other issues. Right? Now you could analyze it 1, 2, 3. That's also possible. Because if it's an absolute gift, then it's gone and nobody has an interest, and he would not be a beneficiary or have an ownership interest because it's just gone. Right? So if it's an absolute gift, you don't need to, then he can't sue because he wouldn't have a beneficiary or ownership interest. And you might want to note that at some point. And in fact, if you did it 1, 2, 3, you might want to come back and say, oh, by the way, if it was a absolute gift, then there'd be no way he'd be a beneficiary. That's one nice thing about typing. You can always come back, right? Okay, so the crucial thing when you're answering is attention to fact detail. Analyzing fact detail and thinking carefully, what can they argue, what can we argue? Fact, 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 fact. And if you do this, if you identify the issue, personal special interest, you identify what the rule is, you identify what facts would be helpful for us, what facts would be helpful for them, then you're going to get your points. You'd have to go way off the reservation on your answer to lose points. You're going to get your points for that. And on this exam, I haven't looked at the answer to this exam, but I just want to go back and point out, just summarize. What we did today was to give you a system. The system is, what do they want me to talk about? Holy moly, it's 20 pages. What do they want me to talk about? Goodness gracious, California threw several landmines in your way for dumb students to go off on breach of contract or something else, blow up. They're done. They're gone. They just dumped everything they know about breach of contract, hoping they get some points. If you talk about breach of contract, you get any points? 0 points for talking about breach of contract. But breach of contract was the first sentence. Yeah, dumb, they got you, didn't they? You didn't follow the steps. Who are the parties and what do they really want? What do they want to happen? Not in legal terms, because you get too narrow. In practical, common sense terms, what do they want to happen? What are they worried about happening to them? What do they not want to happen to them? What's going on here? What's the nature of the case? You can do that real quick, and then go learn the rules, find out what tools are available to you to get those objectives. You'll be able to focus on what's important in those cases and statutes, because you're focused on objective-based thinking. Then go back to the facts and figure out, knowing what the rule is, and guessing kind of what element's probably going to be an issue. Then go back to the facts, and you'll find out the facts that are relevant just to that element. And you're very focused. So instead of, I just read I can't read the whole thing in 90 minutes. Yeah, I mean, you don't start out just read the whole thing. That's crazy time. Let's attack the exam and let's skim through. Let's look for the things we need. Does it make sense? Okay, so you can do this on any MPT. You can attack the MPT in this way. And you should do the exact same thing on every bar exam question, every essay question. You should do the exact same thing. Who versus who, and what do they want to happen? Just common sense, no legal stuff. Okay? And then think for yourself, for the MPE, you have to memorize evidence, right? You got to memorize common law. So the tools are in your brain. Okay? So think about, okay, they want this objective. Okay, so what tools do I know to help them? Actually, I don't know yet. I gotta go read the facts and see what, from these facts, what tools might, these facts might hit these elements, so therefore this tool might be available. These facts might hit this defense, therefore I gotta talk about this defense. That's what they want you to talk about. You see? And if you talk about those things, you're gonna pass. That's the bottom line. Okay, we're way over time. Are there any questions? David, are people looking at you in the window like they want to get in the courtroom? It's Friday, nobody wants in here. We went out of here. Daniel's probably looking at you like, yeah. He's probably saying, what's Mundy doing? Okay, are there any questions on this approach? All right, this has been a very quick, well, seems not very quick, but this has been a quick summary of LEEWS, the LOOS system, developed by Professor Whitworth Miller. I strongly recommend you take his Hagwon, exam taking skills Hagwon. It also, he has half of his Hagwon is how to outline and take notes in class, and the other half of his Hagwon is how law school's SUCK. So that part's it's not very helpful, but okay, professor. I mean, I get it. Well, his point is nobody taught us this in law school. Why did they teach us this in law school? They just threw me on an exam. They didn't even tell me IRAC. They didn't tell me anything. How to take an exam? They told me nothing. I just went to the exam. I just did the best I could do. I did pretty well. But if you asked me what I did, I could have told you. And then when I saw his system, I said, oh, obviously this is actually better than my system. My system was just read for the exam from start to finish, try to spot every issue possible and write about it. And sometimes it worked and sometimes it didn't work. But this, I could have actually done even better if I had his system. Attack it from party opponents, because everything comes back down to what would happen in court, and all your professors care about is what would a practicing attorney do with this? Are you a real life attorney? Do you have the competent skills I can pass you through here, because I can see you have a legal mind. How do you have a legal mind? Because you're not just dumping down everything you memorize, but you're actually responding to the problems that are raised. What problems? Well, the problems that would come up in court between these two opponents, and what rules would apply to them. What within that rule or within that tool, what issue would they be fighting about, and what facts are crucial, both sides. Therefore, what result? But your professors don't even really care about your result that much.
if you got the issue, you got the rules, you figured out where the fight was, you did precise fact details back and forth, it's good enough. All right, well, I'll stick around if you want to ask any questions, otherwise we'll call it a day.